Supreme Court has on a number of occasions, especially in the Saad Rafiq case, very astutely highlighted how laws such as the NAB law have been used as tools of political engineering. When the parliament has the power and the competence to enact a certain law, the parliament also has the power and the competence to then repeal that law or amend that law. This decision rendered today appears to be consistent with our jurisprudence, and perhaps this decision may also bring an end to the NAB law or other accountability laws being used as a tool of political engineering. With the Supreme Court's decision today allowing the federal government's appeal in the NAB case, the amendments made by the Parliament to the NAB law last year now stand restored. Now, while the original decision had annulled and set aside the amendments made by the Parliament, the dissenting opinion rendered in the original decision by Justice Mansoor Ali Shah had very succinctly underscored the infirmities and the lacunas characterizing the earlier impugned decision. Now, before delving into the merits of the decision, it may be important to bear in mind that the NAB ordinance was promulgated by the dictatorial regime of General Pervez Musharraf, and the Supreme Court has on a number of occasions, especially in the Saad Rafiq case, very astutely highlighted how laws such as the NAB law have been used as tools of political engineering. We have also seen that the Supreme Court has previously held in Iftikhar Chaudhry's case in 2010 that where there is an inconsistency between a law which is promulgated by a dictatorial regime and a law which is passed by a democratically elected parliament, then the law enacted by the parliament ought to be given preference over a law which is promulgated by a dictatorship. So if there was a question of any inconsistency between the original NAB ordinance and the amendments which the Parliament had passed last year, preference ought to be given to those amendments. Nonetheless, such considerations failed to convince the majority of the Supreme Court last year when the Supreme Court, when a 3-member bench of the Supreme Court by a majority of 2 against 3 set aside such amendments. Now, while the decision passed by Justice Bandial's bench last year had highlighted that the amendments had violated a number of fundamental rights, including the right to life, the right to dignity, and the right to equality, today's decision highlights and underscores the hollowness of the earlier decision. So the Supreme Court identifies that while the original decision highlighted that the amendments had violated Articles 9, which talks about the right to life, or the right to dignity as espoused under Article 14 of the Constitution, the judgment does not substantiate how these rights had been violated. And given that the Supreme Court's original jurisdiction can only be invoked in cases involving matters of public importance with reference to the enforcement of fundamental rights, so as a result, given that no fundamental right was being violated through these amendments, perhaps the invocation of the Supreme Court's original jurisdiction was also inappropriate. The Supreme Court also talks about how this case could not have been heard by a 3-member bench after the enactment of the Practice and Procedure Act. The one important consideration which perhaps was lost sight of in the original decision is that when the Parliament has the power and the competence to enact a certain law, the Parliament also has the power and the competence to then repeal that law or amend that law. Nonetheless, insofar as the Supreme Court held that while the NAB law could have been introduced or while the NAB law could have been passed, it could not have been amended or repealed, insofar as the Supreme Court held that, perhaps the decision was inconsistent with the established principles of our jurisprudence, and perhaps the decision also betrayed a misunderstanding of the fundamental rights in the Constitution. So this decision rendered today appears to be consistent with our jurisprudence, and perhaps this decision may also bring an end to the NAB law or other accountability laws being used as a tool of political engineering.